Hi, everyone. This is Angela Conklin, and I'm the SVP of Human Resources for Vyve Broadband, but I'm also on the board of C2HR. I want to welcome everyone to this session on the impact of pay transparency. It's something that we're all thinking about, and we're all trying to figure out, how do we navigate it? Well, I have with me an esteemed group of experts to talk about pay transparency. They're going to help us figure out how we navigate the subject. First, I have Mark Konkel, who is a partner at Kelley, Drye. And next we have Wong, who's the SVP of Fair Employment Practices at NBCUniversal. Mark is going to take us through and lay some groundwork for us. Just give us an overview of what's going on with pay transparency. And Cam and I are going to ask him questions and interject and try to get the real scoop for everyone, like what everybody's thinking. So we'd love for the session to be interactive. Please open your chat boxes, post questions and comments, and we'll get to them at the end. So without further ado, I'm going to turn it over to Mark, who's going to talk about pay transparency. Mark?
Angela, thank you, and Cam, thank you. So as Angela just said, this is intended to be more interactive than anything else, but let me just try to sort of set the stage, from a kind of legislative and policy perspective, and then we can go from there, right? Because where the rubber really hits the road is how are employers supposed to implement, these rules? How are they supposed to conform to all of this new legislation? So, what legislative problems being addressed here, right? Why are these laws being passed? So the notion is bargaining power, right? Women make 84% of what men are paid for no good reason, right? So 16% less. The way that legislatures in jurisdictions that care about this kind of thing have tried to deal with the issue is by saying, well, look, to have a meaningful discussion of pay, to achieve pay equity, you need information to be able to have that discussion, right? And so state and federal pay equity laws are aimed at addressing exactly that problem, right? Putting information in the hands of workers or applicants so they can actually say, well, hold on a second, I don't think I'm being paid, kind of equally, right? So equal pay laws have been around forever. And maybe not forever, but for 3 decades, right? So what do they say? They say you can't pay somebody less on the basis of gender. And actually, the laws are drafted not to be specific to women, but obviously that's the social problem, right? You can't pay women less than men without some sort of bona fide business-related reason, and it actually goes beyond gender, but that's really sort of been the centerpiece of the social problem, right? So, as I said a moment ago, what the pay transparency laws are intended to do is to require employers to disclose salary or wage scale information to put that information in the hands of applicants or workers so they really understand, whether pay equity is being achieved or not. There's another piece of this, and it's way beyond the scope of this presentation, but there are a number of like components to this. There are also salary inquiry bans, because the notion is, can't ask somebody about what they made at their prior job. Why? Because that tends to lock people in to sort of baked in disparities in historical pay that may be on the basis of gender. All right, so as I said a moment ago, equal pay protections have been around forever. Geography quiz, can somebody identify that state? It's Mississippi. So in every single state in the country, except for Mississippi, it is unlawful to offer unequal pay on the basis of gender, right, and other protected categories. But transparency, as I said, goes a step beyond just equity. Equity is great, but how are you supposed to measure that? How are you supposed to test that? And so the legislative policy, right, what these lawmakers are trying to achieve by passing these laws is to, again, put information in the hands of applicants and workers. And so you see more states moving to require employers to provide candidates with clear salary information. California started the trend. This was back in 2018. After that, it was Maryland, Ohio, Connecticut, Nevada, Rhode Island, Colorado. Not all of these states actually are sort of, if you think about sort of liberal versus conservative, blue versus red, not all of these states are blue states. So what you're actually seeing is at this point, the light blue states or greenish, I don't know what color that is. You know, there are no state protections in those jurisdictions. But if you look at the, I'm sorry, the darker blue states, no state protections. The light blue states, though, if you just look across those jurisdictions, some of it's predictable, right? Like Connecticut, New York, California, everything on the West Coast, right? Michigan, I don't know, you know, Nebraska. So what you're seeing is an increasing trend towards laws that require employers to provide wage scales and salary scales to allow prospective employees and applicants to evaluate whether they in fact think they're being paid fairly. Now, the laws vary a lot. Some states, if you go back to the prior slide, some of those states would actually require an applicant to ask for salary information before an employer has an obligation to provide that information. Other states, in fact, the bulk of these statutes actually require an employer to affirmatively provide that information. Some of the state laws say that you have to provide the information only after a conditional offer of employment has been made. So there are huge variations in all of these statutes, but the basics are the same, right? And the common idea behind all of the statutes is employers at some point or other are going to need to tell employees what they can expect to be paid, right? That information becomes essentially public when you're associating the scale or the range with a job posting. It's out there, right? In the real world, you're, you know, whatever, you're looking for, you know, you're publishing jobs or putting postings on social media, right? Indeed, whatever it is. So it's out there, it's essentially public. And if an employer deviates from the published range, it may be in violation of some or all of these laws. And so there are, from my perspective as an employment lawyer, here's the problem. You don't want to guess too low and too high, right? You don't want to say, well, the range is going to be from $5 to $500,000, because that certainly would capture anything that you're going to do with respect to a particular published wage range or salary. The problem with that is that these laws all require, by and large, a good faith effort to determine what the real range is. And so we'll talk more about that, how you come up with that actual range.
Mark, hey,
yes.
Mark, it's Angela. I wanted to jump in for 1 second on that
sure.
last slide. It's so easy to go down the rabbit hole of thinking about this only as a compensation subject, right? And it's not just a compensation subject, right? Compensation is really important. You have to have a really good structure on how you've come up with your ranges and why you've come up with your ranges. But we also have to think about it as why, as HR people. And the why for me is that equity started at first and then it became transparent. So we have to be transparent so we can be equitable. And that strategy goes back to the diversity and inclusion strategies, right? We have to connect this to diversity and inclusion strategies. Otherwise, it's just going to hang out there as a compensation strategy that doesn't fit in the organization, because the information, though public, is going to be inside the organization as well. And so for me, that was an aha moment when I was starting to think about this, is that this really hangs on that we want to be equitable and we want to be transparent. So how do we do it in a way where our compensation structures work and that we're keeping it all connected?
So I mean, actually, and right back at you, let me ask you a question, Angela, not to give you a curveball. When you say that those strategies have to be connected to D&I strategies, right? What exactly does that mean? What does that look like?
The purpose of DE&I strategies is to be inclusive and to be transparent and to create environments where a diverse group of people want to work and be. And to do that, we have to pay people fairly and have them feel like they're in an environment that's equitable and transparent. And so those connect. So the reason for doing the compensation is because you want that diversity and you want that diversity to feel comfortable. So connecting the two, we want the diversity and we're going to be transparent. In my mind, that's how it sort of fits together.
Right. Well,
and I would just interject that the idea behind transparency is really to foster communication and discussions and to normalize the topic of compensation,
Yeah.
which is often perceived to be a taboo within a company. Way back when I was a senior trial attorney at the U.S. Equal Employment Opportunity Commission, one of the challenges we had in a global class action against a finance organization on behalf of women was that that particular global financial institution, a very famous one, I'm not going to name, forbade employees from talking about their compensation. In fact, it was a terminable offense.
Yeah.
I think the real kind of game changer here is that that the legislatures are requiring employers to post the jobs with postings, with job salary information, so that the information is really kind of out there in the hands of the candidates, so that there can be conversations. And there is a difference, obviously, between transparency and equity.
It's going to be education for candidates and education within the organization. So, you know, not used to having that information, we're going to have to educate people on what to do with the information.
Right. Well, and look, as an employment lawyer, I care about equity. I care about fairness. As a human being, I care about these things. And as an employment lawyer, what I'm worried about is, okay, so how do you not violate the law, right? How do you comply with the law in the first place and avoid allegations that you violated the law? And I think that the final point of the slide that we're on right now, what's your best protection, which also serves the social interest, is have a rigorous process of actually determining what's the right range and document that process. And we'll get more into this in a second, but what that process is about is, you know, obviously not looking at individual candidates. It's looking at what's the job worth, what are we willing to pay for it, right? And having a process for determining, you know, figuring that value for the company and then documenting that. Because that's that type of process, that type of rigorous, you know, kind of documentation is ultimately what's, number one, going to help employers comply with the law in the first place. Number two, avoid allegations that, you know, the employers have just made up salaries and pay ranges willy-nilly. You know, and number three, really achieve some, you know, Cam, to your point, achieve some fairness, right? To put real information in the hands of workers so they can understand, you know, what they're entitled to be paid. So I started again at the New York pay transparency law. This is just one among many examples. You saw the, you know, the graph or the map a few slides ago about where these laws are coming into play. But let's just use the NYC law as an example. So January 2022, New York City Council amends the New York City Human Rights Law to require pay transparency requirements, right? So what does it, hold on a second, my slide has now freaked out. There we go. At first, and by the way, I would just point this out, we're not going to get into a lot of detail on this particular slide, but the legislatures are figuring this out as they go along. When New York City first passed this law, it was just about salary. So of course, the next natural question to come up was, well, wait, what about like hourly workers, right? So in April of this year, the law was amended to talk about hourly wages, not just salary ranges. You know, and so these are important amendments because I think what you're going to see is an evolution of the statutes in all of these jurisdictions where pay transparency requirements are being passed. So I'm going to focus on this quite a lot, actually, in a moment or two. I would just point out, if you look at the, what is it, fifth bullet on the page, remote workers. The law doesn't apply to positions that cannot or will not be performed, at least in part, in New York City, right? That becomes like a metaphysical question, because the truth is, what's going to happen is, in a sort of post-COVID, or I don't know, maybe permanently COVID world, there are many, many remote positions that could theoretically be performed in jurisdictions that have passed these pay transparency laws. So let's say you don't really care where somebody's working. You know, they could be working in Alaska or California, Washington or Oklahoma or New York, doesn't matter to you, right? But it could theoretically be performed. The way many of these laws are drafted, could theoretically apply to those positions. I don't want to turn anybody to a test case, and I think it's going to be subject to some litigation, but we'll talk about that more in a moment, and like practical strategies for what you're supposed to do. So what are the penalties for non-compliance? Again, we're sticking to the New York City statute. $250,000 per violation is really what it boils down to, right? So what this particular legislature or the city council has done, and it's not dissimilar from what you see in other jurisdictions, is attach really significant economic penalties to potential violations of these statutes. Okay, so the guidance so far, again, just focusing on the New York City statute, Cam and Angela, interrupt me whenever you want. So which job listings are covered by the new law? This is the point I was mentioning a moment before. Positions that can or will be performed in whole or in part in New York City. Now, I think if the issue was ever litigated, what probably a court, right, or some adjudicative body would find is that we're really talking about jobs in New York. And not to get all wonkish on you, but that's a basic principle of just federalism, right? New York City doesn't have an ability to regulate what happens in Nevada. That having been said, the way the statute's written is positions that can be performed in New York City are covered by the law. So here's really kind of like the big point, I think, from a policy perspective, from a employment policy perspective. What are you going to do about that? In theory, these laws would require that you post a salary range with all the risks that come along with that, right? You guess too low, you guess too high, you create disincentive to attract and retain talent, all of that stuff, right? What are you going to do for a job that you don't really care where it's performed from? So I'm thinking of remote work, but it could theoretically be performed from New York City. I don't know if Cam and Angela, you have a view on the right thing to do there?
I would suggest that companies think about what the position salary range would be if performed in New York City, and list that and state that, if the position, this position is remote, if it were to be performed in New York City, this would be the salary range, because, as many of us are aware, depending on which city or state someone works from, or the job is based out of, that can really affect the compensation. One of the necessary considerations in setting compensation is the labor market pool, right? And even the living wage scale and critical information like that, in addition to what the industry would pay and what that kind of job would command in price point. So I think to kind of cover off the situation where it could be performed, conceivably anywhere in the nation, and to meet the regulation requirement, then one can just plainly state that in New York City, it would be X range. I don't know, Angela, your thoughts on that?
I was wondering, Mark, or Cam, have you ever seen, or do you expect to see, where somebody would post multiple ranges? So if in New York, this range, if outside of New York, in, I don't know, Oklahoma, this range. Could you see multiple ranges? I know there was some talk about ranges for progressions in jobs. So you're hired at this and we expect you to be at this in 6 months, right? So but could you see location ranges, multiple?
Sorry, Kim, go ahead.
I was going to say that the legislation doesn't prohibit you from sharing more information. So to the extent that a company feels like the other likely locations could be Oklahoma and they want to put it out there, there's nothing prohibiting you, but the language of the regulation, as I read it, would at least require New York City.
So I'm going to take a controversial view, and I recognize you may not necessarily agree with what I'm about to say. Every time an employer discloses information regarding a salary range in any jurisdiction anywhere, it's an opportunity to say that the employer has messed up following the statute correctly, right? So I would actually, at the moment, and this is just me being hyper conservative, not from a social perspective, but like just, client protective perspective, I would actually urge employers to say, look, if a job's going to sit in New York City, publish the range. If it's going to sit, or any jurisdiction where these laws might apply, right? If it's going to sit anywhere else where these laws don't apply, don't publish the range. I recognize that there is a risk that these statutes, as they're written, is that you could say, well, look, the job could have been performed from Oklahoma or New York or California, Washington, or wherever, Illinois. But I think the problem from a liability perspective, and again, this is just me as the guy who has to litigate this stuff, right, is that the more information you provide, the more people are going to sharpshoot you and the more claims you're going to get. So my suggestion would be, if you're advertising a job that's going to sit in New York City, just sticking to the New York City statute example, fine, publish the range. If you're advertising for a job that could be performed anywhere,
Right.
yeah, including New York City doesn't have a right to regulate what you're doing around the world as NBCUniversal, So I wouldn't publish the range, recognizing that you may disagree with me, just because putting that information out there is a claim generation machine. I don't know do you want to argue about that?
I would never argue with you, Mark, but I would say that, sometimes less is more, right?
Yeah.
And you don't want to bog down a job posting. Why single out Oklahoma, right? Then why not California? Why not, Oregon?
Well, yeah, that's what I was thinking.
Yeah. You have limited real estate anyhow to get the candidate's attention. So I would say, certainly meet the regulatory requirement where you would have to post what the range would be if it was performed in New York City.
Yeah.
I do think that's important to call out, right? If it's a remote job,
Yeah.
and you say this is a remote job, to
Right.
say that in New York City, it would be X, because you don't want to sow confusion for a candidate who's sitting in Idaho thinking,
That's
well, you posted this range. I thought you were speaking to me.
Yeah.
That's exactly why I asked the question, because I could see somebody somewhere else saying, but that's the range. Why aren't you paying that to me? Right. But less is definitely more. And it's interesting to hear both perspectives.
Yeah. Okay. So what's an advertisement? Again, back to the New York City statute, it's basically anything, right? The New York City statute itself, but this is common to all of these laws, relates not only to hiring, but promotions. One question that has come up with a lot of our clients is, what's a promotion? Does it have to be a formal promotion? Does it have to be a title change? What if somebody's responsibilities change? Again, I don't want to get into too much detail here, but based on the way these statutes are written, I think we're talking about bona fide promotion. So the way you should think about, I think as an employer, the way you should think about when will we have to post wage ranges or salary ranges, it would be in, both internally and externally in connection with new hires and internally in connection with promotions. And when it comes to promotions, I think what you're talking about is what we would all think of as a bona fide promotion, right? Which doesn't necessarily have to be a formal title change, but some genuine kind of ascension in the ranks internally. This is also important, and frankly, just so we don't freak everybody out here, all of these laws also just require a good faith effort to determine the minimum and the maximum range. So this is one of the things, again, thinking conservatively as somebody has to defend employers all the time and advise employers all the time. What happens if you guess too low, or if you guess too high, or what happens when you meet you say this job's worth $80,000 a year in terms of salary, and then you meet the perfect candidate in a really tough job market where it's difficult to attract and retain talent, and somebody's worth 85. I think what you want to do is create an internal documented process of how you figured out what the range is. And when you find that person who's worth the $85,000 a year rather than 80, then you're able to say, well, look, we're going to tie that 85 to specific characteristics of the candidate, obviously job related, nothing to do with gender or anything else, right? But, qualifications, credentials, experience, abilities, whatever it is. So one thing that should give employers, I think, some degree of comfort here is that the laws just require a good faith effort to determine the range. And I think you have to be worried a little bit less about, quote unquote, guessing wrong.
Mark, we have a question from the chat. The question reads, I thought it was just stated that if the job could be done in New York, that the range must be posted. I think we have a very sharp reader of your slide, Mark. And I think where you say should, that reader is right. You meant to say must be posted. And you were given should as examples. Those were examples of what the range could look like.
So, just to delve down deeply into the language, if you read the statute on its face, it says if the job could be performed from New York, then yes, you must post a range, right? What's going to really happen is that employers, I'm thinking, Angela, if your company or both your companies, right? You'll be posting for positions or advertising positions that could be performed from a variety of places. So I think the policy question for employers to figure out is, sure, a job where somebody sitting in Anchorage, Alaska, theoretically could be performed from New York, right? But are we going to post a range, a salary range with respect to all of those positions? Again, the more information you put out there, the more you're open to claims of liability for getting the range wrong, for not complying with local statutes and whatever. So I think employers, and I don't know the answer, honest to God, I don't know the answer to this question, right? Employers have a policy decision to make. Theoretically, every job that's remote could be performed from New York City. So are you going to post a range with respect to every single job that you ever put out there, that you ever advertise? Again, I don't know the answer to that question. So I think that we have a very astute question from an astute reader, right? Must you, under the language of the New York statute, post a range if the job theoretically could be performed from New York? Yes, on its face. But if my own view is, and again, reasonable minds can differ, if the job's not one where somebody's going to be sitting in the 5 boroughs of New York City performing the job, don't post the range. Unless you've got a policy reason for wanting to post ranges because you think it's a socially good thing to do, or you're hyper conservative in terms of liability. So I don't know.
I think, Mark, you made a really good point about federalism, right? This isn't a federal law, right?
Yeah,
and
none
so,
of these laws are, right.
Yeah, and so I think that if you think about that, and I'm going to throw in like drug laws, right? There's no federal drug law. There's no, we follow state, right? But I think we have to think about it and manage it separately as well. And your point is that if the intention is not to have this job sitting in any of the 5 boroughs, you wouldn't post a New York job range.
Right. And when the New York City, Angela, to your point, when the New York City Commission, and I'm saying this admittedly from the role of somebody whose job it is to defend employers, right?
Yeah.
When the New York City Commission comes after you and says, whoever you are, and says, you should have posted a range because in some weird theoretical application, this job, quote unquote, could have been performed from New York, we would say, if we defended you or some other company like you, we would say, New York City doesn't have an ability to regulate what happens in Colorado.
Right. Right. And the majority of our employees don't even sit in Manhattan or at all, right? So why would we be posting Manhattan jobs or Manhattan ranges?
Yeah. Yeah. All right.
Good questions. Good questions.
Yeah, really good questions. So let me click through the next several slides. So salary, again, doesn't just mean salary under these statutes. It could be an hourly rate of pay, or it could be a bona fide salary. However, under the New York City law, salary does not include other forms of compensation. So here's one thing, thankfully, none of you have to agonize about. You don't have to sort of figure out the tangible or intangible value of all the other benefits associated with a job, figure out, kind of monetize that somehow, and then include that in a calculation of salary. So, paid time off, sick pay, leaves of absence, sabbaticals, matching 401k contributions, none of those things would be included in a calculation of base pay or salary. All right, so let's get practical and hold on one second. Let's see if I have a good memory for the technicalities. I've been told to stop on this slide, but now we're going to engage in more rigorous debate and ask each other a bunch of questions. So let me just pause there and Cam and Angela, what do you want to talk about?
Well, I wanted to pick up from your last slide, actually, where you talk about what we don't have to post.
Yeah,
right?
let me go back.
The regulation doesn't require us to list anything. The New York City regulation doesn't require us to list anything other than the salary range or the hourly rate. However, companies might want to think about, especially since there is a competition for the best talent. And we hear about the Great Resignation. It might not hurt. Again, appreciating the real estate on a job posting and that it needs to catch people's eyes. Yeah. But it might not hurt to additionally mention the benefits that your company might provide. Because again, in terms of transparency and putting the information in the hands of the candidate, that could set your company apart from other companies for a candidate to say, okay, well, it might be the same salary range between these two companies for the same role that I'm interested in, but wow, I see that NBCUniversal, there's all these other benefits. Yep. And they really value the employees. So, it's just a philosophical
look, I think, Cam, I think it's a great point, and I don't disagree. Obviously we all know we're dealing with an exceptionally difficult market in terms of attracting and retaining talent. So to list all of those benefits, right, or to articulate those as a value proposition for applicants, absolutely. The thing I'd say is, number one, that's not legally required under most of these statutes, and number two, just for an employer who wants to do that, and it makes total sense to do it, right, don't necessarily roll that into your calculation of a salary range, because that's not what these laws require. So I would just, so there's the value proposition, there's the sort of selling that you're doing, saying, hey, look, this is a great place to work, and we've got generous PTO, and we've got matching 401k plans, and a bunch of great stuff, and here's what that is. My own advice would be to keep that separate from, oh, and by the way, here's the salary range, because the laws don't require those other kinds of values to be rolled into the salary range.
Don't monetize it. Don't monetize it. That's for sure. But it's a differentiator. We've seen such success just listing the benefits, right? So what, Mark, you're saying is don't monetize it in that range.
Yeah, or even if you monetized it, right? Just say, here are all the amazing things, and it's worth a gazillion bucks to you, and that's why you should want to work for us, right? Yeah. Oh, by the way, here's a salary range. You could expect to be paid between $65,000 and $95,000 annually, or between $17.50 and $25.50 an hour, or something like that, right? They're really two separate analyses.
Yeah, we have two questions that came in. One is, and I'm going to jump to the one that's relevant to what we're talking about now, and then there's a second one. What about bonus and sales commissions? Would you include those or not include them? And I asked you the same question. I think, Mark, you told me no, they are not included in that range.
Yeah, Angela, that's exactly right. So under the New York City statute, and the answer might vary a little bit from jurisdiction to jurisdiction, and I could try to pretend I could fake my way through understanding all of the statutes, but I'm not sure I do. But by and large, extra forms of compensation like that, or supplemental or additional forms of compensation, are not included. So what these statutes are by and large talking about would be a base salary or a base hourly rate of pay, and not the other kinds of things that you mentioned.
And so you could, like we were saying before, add that to the list of other things. And if you wanted to say how much it was, you could say that separately, but that's not covered under the regulation. And that's just a personal choice for the real estate on the job posting.
It's perfectly said.
Yeah. And then the other question is, if an employer is located in a high cost of living location, would it be geographic discrimination to only hire an employee in a low cost of living location?
No, I mean, well, yes and no. Let me try not to be a lawyer, how I answer this question. So, I mean, would it be geographic discrimination in the sense that you are preferring one geography to another because of the costs associated with the particular geography? Yes, you are discriminating or discerning between the two locations, but there is no federal, state, or local law that prevents geographic discrimination, right? Like, so you can say, hey, look, we'd rather hire people in Alabama because that labor costs us less than people in New York City, God knows, right? That doesn't violate any law. And then you can get in a lot of weird discussions about sort of attenuated discussions of, you know, could there be some sort of disparate impact discrimination claim because of the demographics of particular jurisdictions or whatever. But I think the straightforward answer to the question is you're allowed to prefer to hire from geographies that cost you less.
I read something, Mark, that that some employers were starting to only say, these are the states I want to hire in, and leave out those other states. And that was sort of a no-no, right? If you have a remote position and it's anywhere, don't say anywhere but New York, right?
Yeah. So going back to what these statutes say, and there's a Colorado, for example, statute that addresses this spot on, right? Colorado anticipated that employers would say, we're advertising this job, but we're not interested in anyone from Colorado, in an obvious effort to like not have Colorado, you know, pay transparency laws apply. That statute says, and I imagine these other statutes would be interpreted in the same way, says you can't do an end run that way. If the job can be performed in Colorado, then you have to publish a pay scale or, you know, a salary range. Again, that goes back to my own, you know, admittedly idiosyncratic general advice, which is I wouldn't actually publish a pay scale just because in theory, you could have found somebody in Colorado or in New York City, because I just don't think that Colorado has a right to regulate what happens in any other jurisdiction or New York or, you know, anything like that. So great question.
I did want to share with the audience, given that there is so much work, right, to come up with ranges for New York City jobs or remote jobs that could be performed in New York. I always try to find the silver lining in things, or, you know, look for the lemonade in the lemon. So, you know, in the process of coming up with your ranges, I would suggest that you look certainly at all the incumbents in the role. And to Angela's earlier point, in terms of applying a DEI lens, right? Look to see whether it's equally favorable across the demographics, race, ethnicity, sex, et cetera. And if you see differences, I think it's a good time to look into the reason for those differences and consider whether you want to make adjustments ahead of the implementation deadline. Then that way, you know, you would care for the population you have in your company, you know, who you should value, as well as setting the right range in good faith for external candidates. And then also with regard to pay equity as a whole, another, you know, practice I would suggest is as you are considering what package to provide a candidate that you love, to have other parts of your process involve someone who's not sitting as close to the candidate that you're seeing, to provide some objective rigor, especially if you're looking at the higher or lower part of the range, to consult with your human resources professional or your comm person, just to ensure that there's some objective rationale for, you know, whether you're coming at the low or the high end, or especially if you're looking for an exception and going above or below. While it is about good faith when you set the range for the job posting, you also want to have consistency, right? Because that gets you to pay equity.
Yeah. Well, and Cam, if I could just kind of come over the top of that comment and say, you know, I don't want to be perceived as, the guy who's saying, here's how you avoid your obligations under these laws. I think that these laws are going to force more and more employers to take a serious objective look at their pay scales, and that there's a really legitimate value, obviously, in doing that. Because at least in my experience, Cam, probably yours, Angela, maybe yours, when employers actually do take, Cam, as you put it, a rigorous look at their pay practices, what they find are unaccountable discrepancies in the way that people are paid, right? And so what these laws will essentially force a lot of employers to do is take an honest to God look at how do we compensate certain types of work rather than certain types of people, and it's the certain types of people part that becomes the discrimination part of it, right? And the inequity part of it. And to establish, a kind of objective structure to pay. I think a lot of big sophisticated companies do that already. I think lots of employers don't do that. And these laws will accelerate, those efforts on the part of more employers.
And there's some huge benefit, Mark and Cam, to getting it right? There's huge benefit from an equity perspective, but many surveys have been done that show that employee engagement is really driven by people feeling like their employers are being transparent with them, and that they're also feeling like their employers are treating them fairly.
Yep.
And they don't want to leave. And that's what we need in this great resignation, right? So if we can get it right externally and internally and start to have these conversations that we really haven't been open to having, then our current employees can be even more engaged with us because they feel like we're not holding anything back. And that subject's not taboo. That's how we started, right? With you're forbidden to talk about your compensation.
I agree 100% with you, Angela. I mean, we have to put the people at the center of things. As an employment lawyer, right, it's easy to be focused on our policies, our practices, our processes, which are all important because we want to have objective rigor so that we can be fair. But all of that is in service of the people. And so we need to be comfortable having the conversations with our employees when they come to us and say, oh, I see this range. Why am I on the low end? We have to be prepared for that. And we have to arm our business managers to have those conversations to explain why that person is on the lower range. They don't have the training that the person who's going to come in might have. They don't have the same years of experience, or it might be a different geography. So, and those are legitimate reasons.
Or whatever it is, right? But to have an answer to the question other than I don't know.
Exactly.
Or
no comment. And let me get back to you.
Yeah, call HR.
Right. And you can weave in then the conversation about career progression and career planning, so that the employee feels valued, and it's not just a conversation about a number, right? It's about them and where they see themselves in the company, and how you want to ensure their success. So I think it's just an entree for good conversations if we're not afraid of them to start with.
I love what you said, that the people are the center of this, and that's what we have to think about, right? It's compensation, it's all of that, but people have to be at the center of what we're doing to make sure it's done right. We have another question. While I am for pay transparency, do we think it also limits the ability for someone to negotiate? One challenge we're discussing in maintaining internal equity and keeping true that pay range or number. So does it limit someone's ability to negotiate?
Well, yeah, I mean, so look, the three of us may have, I'm sure we will all have maybe slightly different views on this. But the way I understand the question is, look, you've got this range and somebody comes in and says, hey, listen, you published a range that's from, again, making it up, $70,000 to $100,000 a year, right? I'm actually worth 120 because of my unique skills, ability, credentials, whatever it is, right? Does that somehow lock an employer in to saying, sorry, the range is from 70 to 100? that's why I think, number one, it's important to try to get a rigorous process in place, as Cam, you mentioned several times, Angela, too, of really figuring out what is the right range, but also going back to that idea that it just, all an employer has to do under any of these statutes is make an honest to God, good faith effort to come up with the right range. And if you meet, the right candidate who's worth something above the range, I don't think you will have violated the law if you can identify objective factors that would allow somebody to negotiate for more. Now, look, I think what's at the core of the question, though, is do the laws sort of put downward pressure on qualified employees negotiating for more? They probably do, because you're publishing a range, right? But I don't think that necessarily limits the ability of you as an employer to step outside that range, whether it's above or below the range, based on a specific candidate and that specific candidate's objective credentials. Angela, Cam, I don't know if you disagree with what I just said, but.
I don't disagree, but I see the clock running. And I just want to put one other piece of information out there.
Sure.
And that is for federal government contractors, you have to remember that you have to post a pay transparency policy, which basically says there can't be any retaliation for employees talking about their compensation. So don't forget that notification requirement, the posting requirement.
Thank you. So
much.
much.
Thank you for reminding us. Yeah, Angela.
Yeah, Mark and Cam, and great conversation. And I know that we're just the tip of the iceberg here, right? There's more to come, Mark. There's more, that we can see in states moving toward this. And so we're hoping that future C2HR will have another session that we can talk more about this and how things progress.
Yeah, check back in a year. It will have been an interesting time.
Yes.
Oh, I see that we have about 7 more minutes, actually.
Okay.
Oh, do we? Okay.
Oh my
great.
gosh. Okay.
Oh, well,
Okay.
that's a wealth of time.
I have more questions. I'm sure you do too, Cam, right? So,
Yes.
Mark, have you seen anybody get fined or called into question by, I guess I'm saying the DOL? Is that the right entity?
Well, so there is no federal law, so it's not the U.S. Department of Labor,
Yeah.
but there would be various entities, right? So, in Colorado, it's the, Colorado Department of Labor. In New York City, it's the New York City Human Rights Commission. And there would be, kind of various entities that are charged with enforcing these laws. Long story short, I mean, in New York City, the law hasn't even gone into effect yet, right? So these are all brand new, which is part of why you hear me hedging on how to approach these laws, right? Like the way we as lawyers think about it is, okay, if Mark's going to take a position that the New York City law doesn't apply to some position that's going to be filled from whatever, Montana, right? The way that we figure out that liability is to say, well, I don't know, has that ever been litigated? Right? There is no litigation experience. There is no enforcement experience, under the bulk of these laws yet.
And in Colorado, in where it started in California, right, 2018.
Yeah.
Are the laws in place?
Yeah, so the laws are in place in California, but again, not a lot of litigation or enforcement experience under them yet. Yeah.
What do you suggest for companies that have offices next to where, like New York, right, when it goes into place, or a place next to California? What are you suggesting, by the neighboring states?
So like, for example, if somebody lives in Connecticut and commutes into New York. Yeah. So the statutes all appear to apply, or I shouldn't say appear to, the statutes all do apply to jobs in particular jurisdictions. So if a job's in New York City and the statute's drafted as if geography were simple nowadays, that would apply. If somebody lived in Connecticut and commuted into New York, the pay transparency statute would apply to the position where somebody's working in New York, kind of regardless of what their home jurisdiction is, or where they may reside.
Got it.
What are we leaving out? Do we have other questions?
Yeah, we have some other questions. Should every person part of the interview process be equipped with the range? Should a candidate ask?
I, my thinking around that is, it doesn't hurt, I suppose, to have the posting, right? I think everyone who is part of the interview process should be familiar with what the posting says, since they would really need to know what the job requirements, responsibilities, preferred qualifications are. And should that question come up, then they would have to answer. But I think equally, it would be fine if someone is participating as an interviewer, as a stakeholder, that they can direct that question to the hiring manager or someone else. And I don't think, there will be anything wrong with that.
Yeah, it's definitely part of that internal education. That it's better if most people know, and it's going to be posted anyway. So what advice would you give to a company who will start pay transparency, range posting to his internal employees? That's a great question. What advice would you give the company who will start pay transparency, range posting to his internal employees? I think it's make sure the ranges are correct. That's a starting place. And understand, to Cam's point, employee first. Where are your employees in their head, right? Do they feel like they're being paid fairly? Do they not feel like they're being paid fairly? What's been discussed before? Start with sort of that component, I think, is really important. Is there an uphill battle? I don't know, Cam, what do you think?
Yeah, I mean, the regulation does require that for any posting, whether it's internal or external, it has to have that range. And, I agree that before you even have that in the document to be posted, you're aware of who the incumbents are.
Right.
Or even who might be interested in that role. So you, as a manager, I think it's good practice to even share internal job postings that you think people might be interested in, to say, we're so excited that we can continue to expand and grow our department, and here are some promotional opportunities. If you have any question, look forward to it being an opportunity for us to have a dialogue about your career. So certainly, you need to feel comfortable about that range for the position and where the other people may sit relative to that.
And it's people that are interested in that job, but people could be comparing my job to that job. So why is my job paid less than that job, right? So there's the candidate, there's the person who's interested in the job, and there's just the bystander saying that job is worth more than my job, right? So it's interesting because the people you're communicating to are going to have different perspectives.
So that is a great point, Angela.
With just a couple minutes left, I've got a question for you, Angela, and for you, Cam. And it's the mother of all questions.
Oh no!
No, seriously. So there are obvious risks associated with posting ranges, right? Because you could get the range wrong, and right, people can sharpshoot you. There's an obvious, Cam, to the point you've made several times now, an obvious benefit to that type of transparency, right? So should companies take a jurisdiction by jurisdiction approach and try to avoid publishing ranges where they can? Or should you say, look, this is, these laws exist in an increasing number of jurisdictions. It's just better from a policy perspective to put the ranges out there. Like, what do you think? I know that's like, the $60,000 question or the $60 million question, maybe, depending on the litigation. But like, what do you think? No, but seriously, what do you honestly, I don't know there's a right answer to this question. What do you think the right answer is?
It's what your organization is prepared for.
Yeah.
Right? It all depends on your organization. I could say, in my humble opinion, it's better to be transparent because you're going to engage with your employees that way and just open up the kimono. But if you're not ready and your employees aren't there, then it would be a problem. So it's got to be a balance of both. I don't know, Cam, what do you think?
I agree with you that it definitely is where your company sits, right? In terms of even having that information for all the jobs that you could possibly fill across the nation. At our company, we have a lot of positions. So that is a tall order to start with. But I think depending on the company's philosophy, that could be your aspirational goal, to be able to post a range for all your jobs. And to be honest, it'll make it easier to implement as well. I mean, once you go through the hard work of getting all the ranges for every position, because then you don't want to have a patchwork, right? Whether
Agreed.
it is
Agreed.
Chicago now or New York or whatever.
Yeah.
You know,
And so look, I mean,
overtime.
I guess the note that I would end on is, and Cam, you put it perfectly, aspirationally, should all employers be able to be completely transparent and understand that there's a completely rational kind of system to the way they approach compensation? Absolutely. Are most employers like that? No. So, undertake that process now of really doing a genuine pay equity analysis, in order to be able to defend, ultimately the information you're going to have to disclose under an increasing number of these statutes. And we are 38 seconds over time, and no one is yelling at us in the chat yet. But I don't know, Angela, you want to take us out?
Yeah, thank you, everyone. I really appreciate it. And thank you for the questions, and Cam and Mark. This was amazing. I found it really interesting. I hope everybody else did. And as Mark said, please stay tuned, because we're hoping to have a follow-up session that C2HR is going to put on. Thank you, everyone who's attending the session, and we hope that you're learning a great deal. And that's it. Thank you.
Thank you.
Thank you, everyone.